WikiLeaks founder Julian Assange has been arbitrarily detained by Sweden and the United Kingdom since his arrest in London on 7 December 2010 as a result of the legal action taken against him by both governments. The expert panel called on the Swedish and British authorities to end Mr. Assange's deprivation of liberty. I think the recommendation is quite clear. Respect his physical integrity and freedom of movement, and afford him the right to compensation.
Okay. Hello, everybody. I'm Randy Credico. This is Randy Credico Live on the Fly here on 99.5 FM in New York City with a very big show today. Last week we had a special 90-minute program on the first day of the Assange hearing. Well, it's been a week now, and there was another day. A lot has happened. And so thank you, Linda Perry-Barr, for giving us the extra space today. This is normally a 30-minute show, but we've got 90 minutes, and we have an incredible lineup. We have Daniel Ellsberg coming up. We have Julian Assange's partner and mother of his two children, Stella Morris, coming up. And we got Bob Boyle, who was a witness, and John Kiriakou. But we're going to get underway right now with one of my favorites, Ben Weisner. If you don't know who he is, of course you know who he is. He's Ed Snowden's attorney. He's also the director at the ACLU. I can never do this right with him. ACL Speech, Privacy, and Technology Project. And he's blocked by the real Donald Trump, who's not online anymore or on Twitter. Hey, Ben, welcome back. It's been a long time.
Hey, Randy. Good to be here.
All right, good. I got to tell you, we've talked about this. The last time was like 8 months ago. And then earlier that year in 2020, we spoke. And, you know, we cover some of the same ground on this Assange case. But, you know, the ACLU, along with 25 other groups, just sent a letter to Merrick Garland asking for them to dismiss the case. Before you get into that, what is your overview of what you saw last week in London?
Well, look, I think a lot is riding on what happened in London. And, you know, I say that because none of us really wants to see what will happen if this case ends up back in a U.S. courtroom. We talk often about how there has never been a prosecution under the Espionage Act of someone for publishing truthful information, that this indictment is the first time that the Department of Justice has gone down that road. But, you know, I recently did an event for the 50th anniversary of the Pentagon Papers case, and I know you're going to have Daniel Ellsberg on later, and he may want to add to this. And we think of the Supreme Court's decision in the Pentagon Papers case as establishing this extremely broad First Amendment protection for journalists. And in one sense, that's true. It prevents the government in almost all circumstances from blocking publication in advance. But it says nothing to prevent the government from prosecuting publishers. And in fact, the justices on the court pretty explicitly left open the possibility, without deciding it, that the government might be able to do what it's now doing to Julian Assange. So we should not see it as a done deal that if he ends up in a U.S. courtroom, the First Amendment will knock out the government's case. Just because this prosecution is unprecedented doesn't mean that it isn't extremely dangerous. And we can talk about, you know, more why I think this was a really deviously chosen one to set this kind of precedent. But again, many of us will be making strong First Amendment arguments if that ever ends up here. But by far, the superior resolution here would be for the UK courts to correctly rule that this is a political offense. The Espionage Act is, by definition, a political statute, and therefore not an extraditable offense. That in itself would set a terrible precedent if publishers could be sent to face prosecution for violating other countries' secrecy laws. So we really want to see a strong ruling from the UK courts, as your listeners will remember. The courts have so far blocked his extradition on the ground that he would face brutal treatment in U.S. prisons and that his life would be in danger. That's, of course, true. But I think that it would be a much stronger ruling if those courts said that neither Julian Assange nor any other publisher can be extradited to the United States to face trial under the Espionage Act.
Well, what is going on at the Department of Justice? Merrick Garland seems like a fair-minded individual. I know somebody that I worked with who I think was connected to the ACLU, who's third in line there, Vanita Gupta, and I'm wondering why they would continue a Trump prosecution when we thought this was going to be a new page when Biden came in.
Look, let's think about why they might not be doing anything right now, real talk, right? Assange is not popular in either party. And right now, they don't feel the urgency that they should be feeling because they know that this case is going to be in the courts in the United Kingdom for months or years longer. And my strong belief is that there are many people in the Department of Justice who are quietly hoping that the British courts will take this off the table and not force them into what will be an extremely complicated situation if the British courts greenlight the extradition, because then they really will have to decide whether they want to be the first Department of Justice in the history of this country to prosecute someone for publishing truthful information provided by somebody else. They don't have to make that decision yet. Because they can sit back, they can focus on their other priorities. They certainly have enough on their plate, and they can watch this play out in the UK courts. And if and only if the British court system says that there's no obstacle to extradition, will this become a political problem for them? That's my belief. But look, and we've talked about this before, there has never been a unified U.S. position on the Assange case. We know there was a criminal grand jury from the very beginning, from right after the Manning leaks. We know the Obama administration considered bringing a case and ultimately decided not to because they thought they couldn't get around what they called the New York Times problem. They couldn't find a way to construct a case against Julian Assange that would not put other national security journalism at risk. Even in the Trump administration, I'm sure there was a difference of opinion about whether to bring these charges. From some people in the Department of Justice and others in the CIA. We'll talk more about that in a minute, and some in the FBI. And ultimately, what you lost was the people in the Obama administration who put the stop sign up, and the hawks won the day. That's going to be the case again in the Biden administration. You're going to have people in the FBI and the Department of Justice who want to see this case go forward, and you're going to have people like the ones you referred to a moment ago who understand what kind of precedent it will set. So I am very, very, very much hoping, both because I'm worried about what will happen in the U.S. and also because I think this is an important global precedent, that the UK courts will issue a very strong ruling against extradition.
Let's go back to the Yahoo News explosive story that they put out when we were talking. You were saying in a minute talking about the CIA. What kind of impact did that have on Washington, if any?
Well, we'll see. Look, I was a little bit surprised that the really important investigative reporting that Yahoo did, Michael Isikoff and his team, was not picked up by other news outlets because I think it was a massively important story. And I was expecting to see the New York Times, the Washington Post, and others try to recreate that reporting and come up with their own visions. Maybe they still will. But look, you're going to hear this when you speak to Daniel Ellsberg in a little while. Remember that there wasn't one Pentagon Papers case. There were two.
Yes, go ahead. Tell us that.
There was the case where the Nixon administration tried unsuccessfully to prevent the New York Times and Washington Post and others from publishing the papers. And then there was the criminal case against Dan. And that case was never concluded because the judge in that case dismissed the charges with prejudice, meaning they couldn't be refiled, on the basis of outrageous government conduct. And what was that outrageous government conduct? It was all kinds of things, but principally it was about surveillance of Daniel Ellsberg's attorneys and their attorney-client relationship, breaking into his psychiatrist's office. All of these kinds of dirty tricks that were in this Yahoo News article. So if these kinds of facts were put before a judge in the U.S., I hope what he would do right away is hold an evidentiary hearing and haul the government into court and make them give a full accounting of whether they conducted surveillance on Assange's attorneys. We know they have in the embassy. Whether they have records of that relationship being compromised, what they can say about it. If they can't demonstrate that Assange's right to counsel wasn't compromised by their bad acts, then this prosecution should not go forward. But look, before we even talk about what effect it will have in the U.S. courts, I really hope that this provides even a stronger basis for the courts in the United Kingdom to say this is definitely not an extradition that should happen. This case is just, it stinks to high heaven.
Well, they're spending a lot of money. They're going against, Assange has got X amount of money. You're dealing with a mammoth organization, which is the Justice Department and the Crown Prosecutor Services. They got endless supply of money. How does Assange fight this legally? I know there's a lot of volunteer attorneys, but there's a lot of paperwork and there's a lot of investigating to go on. Let's say,
look,
go ahead.
He's got some of the finest lawyers in the United Kingdom who are on his side. The one thing that I'm not worried about is his having the best defense that's available to him, because there's an all-star team of lawyers who are in his corner, both in the UK and in countries around the world, who are, standing by, ready to do their part when they're called upon. That doesn't bother me. I mean, we're always used to having, the ACLU is huge in the United States, but we're just a few hundred lawyers. The Justice Department is 11,000.
Right. That's what I'm talking about. There's so many lawyers.
The important thing is the quality of the arguments, and right now, that is at the bottom of my list of concerns. Here's what's higher on my list of concerns, and again, we've talked about this before. The United States is in court in the United Kingdom making the argument that an Australian publisher needs to be sent to Virginia to be prosecuted for the felony of breaking the United States secrecy laws. Think about that for a minute. That the United States is making the claim that its own secrecy laws bind foreign publishers criminally, and that they can be forced in chains to fly to the United States and go to prison for violating U.S. secrecy laws. So much of what we're talking about when we talk about these kinds of prosecutions is about precedents and traditions, not necessarily black-letter law. What precedent is it going to set if one of the leading democratic nations extradites a foreign journalist and publisher to be prosecuted for violating secrecy laws? And what ground will we have to object if China, if Iran, if Azerbaijan, if any country in the world says, we now want to extradite a Guardian journalist, we now want to extradite a New York Times journalist because they published our country's secrets in violation of our laws? Now, I'm not suggesting that extradition would happen. I'm just suggesting that the United States would have no principled basis for denying it.
Right. Do we have Daniel on the other line? Is he there? Do we have? Yeah. We actually have Daniel, but we have Stella Morris in 1 minute. I'm going to be kind of extemporizing this at this point.
It's an embarrassment of riches for you, Randy.
Well, that's good. All right. I want to just see if he's there, if Daniel's there. Can you hear us, Daniel?
I'm here. I can hear you. Can you hear me?
Yes. We got Stella Morris coming on. I just want her to know we're going to spend a few more minutes and get you on in like 5 or 6 minutes. I know Ben was just talking. You missed the first 15 minutes. Why don't you gentlemen say hello to each other? It's been a long time.
Hi, Ben. Hi. Good to hear from you.
Nice to hear your voice.
I wish I'd heard from any news that I missed. Okay.
No,
we're not on the air, are we?
Yes, we are on the air. We just want to make sure you were on the air because I know we have you there. Is Stella on the air? Do we have her? I want to make sure. All right, so we're waiting for Stella Morris to get on the air. I'm going to have to continue with you guys, which is a good thing. Daniel, let me ask you right now, Ben just laid it all out, the dangerous precedent this would set. And why don't you kind of take it from there, what you think would happen if Assange is brought over here and is successfully prosecuted and sent to prison?
Yes, yeah, first of all, I suspect, and Ben would know more than this, but I suspect that contrary to their assurances, if they don't send him to Australia, he'll be in isolation, just the way Chelsea Manning was for 10 and a half months until a popular pressure got her off. Mordecai Vanunu, my friend in Israel, was kept in isolation for 10 and a half years out of his 17 years that he got for revealing Israeli nuclear program. And I think they would take the attitude that Julian has information still to give that he hasn't put out. They don't want him in the general population. That's just my guess. But the precedent in terms would be the very first time that a journalist had been prosecuted for telling the truth to the American people. They've avoided that. They've considered it often. As a matter of fact, in my own trial, in which back in 1971 to 73, when I was the first person to be prosecuted under the Espionage Act, same charges as Julian is facing now, for giving top secret information to the American people, none of which was ever demonstrated or even plausibly claimed to have harmed national security, meaning it should not have been classified. But in any case, at that very time, Nixon was trying to had a grand jury looking into prosecuting Neil Sheehan and Hedrick Smith of the New York Times, and probably others. And that grand jury ended, was terminated. We don't know exactly why, but probably for the same reasons that my trial was ended. Finally, the discovery of illegal wiretapping of us and perhaps other intrusions. In my case, the trial was ended in large part because of the discovery of government crimes against me that have been considered or perpetrated against Julian, specifically illegal wiretapping, in Julian's case, surveillance of him, even his lawyers' conferences and his doctors' conferences in the Ecuadorian embassy, the information going to CIA, and then discussion of assassinating him or kidnapping or poisoning him, either the kidnapping or killing him by poisoning. In my case, a dozen CIA assets were brought up from Miami, Bay of Pigs veterans, to incapacitate me, Ellsberg, totally, which meant either killing me or shutting me up. I think it was probably the latter. The special prosecutor felt their intention was to kill me. And when that came out, my charges were dropped, and more importantly, those figured in the impeachment of Richard Nixon and made the war endable when he resigned, facing impeachment. Obviously, Julian's trial should be terminated. The charges should be terminated just on those grounds alone, just as mine was. And however, if, as you say, they do bring him back, that will set a precedent. It will not be the last. We know that the previous president would have certainly continued with other prosecutions, but that appears to be true of Biden as well. Few people have really commented on just how outrageous it is that President Joe Biden, a Democrat or liberal, is carrying on this blatant contradiction, violation of the First Amendment, of freedom of the press, freedom of speech, which is the basis of our democracy. And for Trump to do that is somehow not surprising. It was predicted by the ACLU even before he got in that he would build on the precedent of President Obama, bringing many cases like mine against sources to the press. But Obama refrained from doing that in the case of Julian, because it was so obviously a blatant violation of the First Amendment, much so, even more so than in my case. And by the way, there's strong legal opinion that to use it against me and the others that Obama did was already unconstitutional. And the Supreme Court has never ruled on that. It has not come up to this. It's come up, but they have rejected hearing it. So it's never been ruled as to whether that use of the Espionage Act against whistleblowers is constitutional. And the earlier Supreme Court would almost surely have ruled that it was unconstitutional. Obviously, with the present Supreme Court, you can't count on their taking the Bill of Rights very seriously. So it could be that we would lose the First Amendment essentially and live, like most countries in the world, on government handouts when it comes to information about what the government is doing in our name, especially in the area of so-called national security. So it's extremely serious problem here, which the press, I have to say, has been very derelict generally in not recognizing that this is aimed directly at them, that Julian is not distinct from other members of the press, as some have wanted to imply. His precedent would clearly be used to prosecute other journalists.
We're talking with Daniel Ellsberg and Ben Weisner of the ACLU. Ben, listen, I'm working on getting Stella on. I want you to either riff on that or ask Mr. Ellsberg a question, if you would.
Well, I just to riff on that for a second. I mean, Dan is absolutely right that the central questions of this case have never been resolved by the U.S. Supreme Court, which is the reason why I think both of us fear this particular case being the first one that would go up because of the cross-partisan hostility here. But Dan, as I said earlier on the show, it's not just that the Supreme Court has never ruled on whether the Espionage Act can be used against a source. In the original Pentagon Papers litigation, it left open whether it could be used against a publisher. That was not resolved in New York Times versus United States either. So we shouldn't be confident, as Dan suggested, that the First Amendment will solve our problems if this case washes up on our shores. By far the better chance here and the stronger hope is that the courts in the United Kingdom will refuse to extradite both on the humanitarian grounds and on the very strong legal grounds that this is a political offense that should not be extraditable. Dan?
Ben, can I ask you something? This is ironic. I'm glad to hear you say that they have a good basis for refusing extradition on those grounds. Isn't it the case that in England, with the Official Secrets Act, either I or even Julian would be clearly held to be in violation? They have an Official Secrets Act. We don't. We have a First Amendment. They don't. That was a product of the American War of Independence. Is that wrong?
No,
Am I wrong?
It's right. It's right. I mean, the problem is that, as we have both commented over the years, the Espionage Act has been creeping closer to being an Official Secrets Act, at least as to people who work for the government. But this is the case. If you read carefully the opinions in New York Times versus United States, which was the Pentagon Papers injunction case, the court expressly leaves open the possibility that the New York Times or others could be held criminally liable after the fact, even though they can't be enjoined before the fact. And we haven't, in these last 50 years, seen a single instance of that because of the culture of the First Amendment in the United States and the recognition by the Department of Justice that there is massive overclassification. The public has a right and a need to know lots of important secrets. But this is the case that could break things open. You have Democrats that don't like Julian because they blame him for Trump being elected. You have Republicans who are very enthusiastic about setting a precedent that prosecutors can be reported. So of all cases to go to the Supreme Court to test these vital principles, this would be the worst one.
Yes, that's, you've really turned my head around in a bad way, Ben, because I've always thought of those obiter dicta, I believe they're called, in the Supreme Court, where people made the comment, the justices made the comment, four in particular and five by implication, that there could be a prosecution. I've always read that as allowing a prosecution of me, a source. Are you saying that they left open a prosecution of the New York Times?
Yes, very much
dear.
so. And I just did an event with Burt Newborn, who you know, formerly of the ACLU, who represented the ACLU in that case, and he said the very same thing, that what we've had in this country is not a legal precedent that's prevented these prosecutions, but a very, very strong constitutional tradition that has prevented these prosecutions. Look, I think, and we would raise very strong First Amendment arguments if this prosecution ever happens. And I'm not suggesting that we would necessarily lose those. I'm just saying that the fact that there has never been a prosecution of a publisher under the Espionage Act is not because there is any holding of the Supreme Court that would prevent it.
Right. Well, I knew there was no holding that would prevent it. What you're telling me is that they made comments that not only opened the way to the prosecution, which occurred, I was prosecuted, but that they would have, they were actually allowing, let's say, the grand jury proceedings that were going against Rick Smith and Neil Sheehan at that time. And I really had never thought of that. My own thought about those, of course, I read those opinions at the time. And my own thought, I was not happy, of course, that they were almost calling for my prosecution on this unnecessarily. They didn't have to say anything about that. But I put it down to the ignorance of these Supreme Court justices, like all other lawyers, to the law and the application of any act, including theft or Espionage Act, to leaking, because there never had been a case.
Right.
I've talked to large audiences of judges in the past, believe it or not, and lawyers and journalists on separate occasions, and found that almost none of them really knew anything of the background of the First Amendment law in this case, but especially the Espionage Act. And that was natural. They hadn't studied it in law school at all. There were no cases. And that's the situation that the Supreme Court found itself in. Several of them complaining about it. Then in a matter of days or a couple of weeks, they were addressing these things for the first time. And so I thought, okay, they made those comments, but maybe they wouldn't stand up later. You're not encouraging me.
We'll see. Look, you'll remember, and Randy, please cut in when Stella is ready, and interrupt us, because Dan and I can speak to each other all day.
Yeah, I understand that. It's okay. She's there's some kind of transmission problem. They're waiting, but we're going to go to the. You guys stick with us. We're going to go to the news. We have to take a news break right now, a short news break. Can you guys both stick around?
Sure.
Okay, we'll be right back. Okay, I'm Randy Credico. This is Randy Credico live on the fly, 99.5 FM, WBAI, Free Speech Radio in New York City, here in Brooklyn. Our friends over there in London, I think you may want to unmute. I think you might be on mute. So please unmute, because we'd love to be listening to you as well. We have... This is a special edition of Assange Countdown to Freedom here at WBAI. We are talking right now with Ben Weisner of the ACLU and the great whistleblower, Mr. Daniel Ellsberg. Thank you, gentlemen, for holding on. And can you kind of continue where you left off before? I know, Weisner, you've got a bookmark on it.
Dan, what were we talking about?
Ben, I have a question for you. Do you agree with me, what I just said, that it's particularly outrageous that a Democratic president is pursuing this particular case?
Yes, I do. As I said before you joined, I think they're not feeling any sense of urgency because they know that it's going to be tied up in the UK courts for months or years. Probably some of them quietly hope that it will be resolved there, so that they won't have to make a decision. Whatever decision they make is going to be unpopular with some people in their own party, and so they would prefer, I think, for this to be handled in the courts in the United Kingdom. And then, of course, there are others, as there always have been, including Democrats, who have wanted to bring this case. The Obama administration ultimately decided not to do it, but that's not because there weren't people who were pushing for it internally. There were many people who were pushing for it. They had
Wait, let's name names there for a minute. I think we can assume Hillary Clinton is one of those, and conceivably that influenced Biden. He's vice president. She was Secretary of State. But do you mind naming names? Who besides Hillary Clinton in the Democratic Party wants to see the First Amendment stopped and Julian convicted? Who would that be?
Look, I'm not just talking about elected officials in the Democratic Party. I'm talking about people who work in the FBI, people who work in the U.S. Attorney's Office, in the National Security Division of the Department of Justice.
Right, okay, fair
There's
enough.
always been a debate in government. This has never been a uniform decision. There were always people who were pushing for this prosecution. And at the end of the day, it was people on the political side, and Eric Holder, who said, we can't get around the New York Times problem. We can't prosecute Julian Assange without exposing other national security journalists to criminal liability for doing their work. There's no way that we won't be loading that weapon to be used against other journalists. There's still plenty of people who work for those agencies, but I also think that, if you look at the Democrats who sit on the intelligence committees in the House and Senate, not all of them, but certainly plenty of them, they would be delighted to see this case go forward.
Okay, you've answered. Yeah, I understand.
Right?
Yeah.
The incredibly dishonest investigations and reports they put out about Snowden, tell you that, these people are very much doing the opposite of oversight over the intelligence agencies. They get the most donations from the security contractors. And the real question is, who will be the first Democrats in Congress to stand up and denounce this prosecution? Because so far we haven't really seen any.
God, that's terrible. Well, yeah, you say Democrats. Oddly enough, I think Ron Paul and Randy Paul both criticized that. And in fact, they're among the only two members of Congress who ever said anything favorable about me in public. I've met plenty of them at their fundraisers or shaking hands or even taking a photo, which I notice if they're willing to do that. But in terms of saying it in an interview or in Congress, no. Rand Paul and Ron Paul are the only ones that come to my mind.
Well, let me ask you guys here about the media. We are on it.
Right.
Pacifica in San Francisco, Dennis Bernstein has done plenty. We've been doing this here for 5 years. I know there are people who give us some heat over it, but you take a look. I don't want to name names myself, but Ari Melber seemed to be very interested in me when I was supposedly the back channel, which I wasn't. There was no back channel. But MSNBC has totally dropped the ball. Isn't this like leaving, in my opinion, a guy in the trenches and going AWOL? Because
So two things, Randy. First of all, I will say this, that the major news organizations, when the second indictment of Julian Assange was released, that included felony charges for publication, not this really concocted, really contrived kind of hacking charge, which is factually nonsense. But that charged him under the Espionage Act for publication. Most of the major media outlets condemned that and said that it would be a threat. But they haven't done two other things that would be really vitally important and helpful. Number one, they're not reporting on it enough. They actually need to be raising a stink. They got scooped by Yahoo on a big story, but they haven't followed up, and they're not covering the proceedings in the UK closely enough. This should be a huge story in the United States, and it hasn't been. And number two, the corporate side, the owners, the people who own Dow Jones and the Wall Street Journal and NBC and the New York Times should be going to the White House and saying that this case is an existential threat to national security investigative journalism. And I'm not saying the reporters, I'm saying the owners, the people who hobnob with the president and his circle. They're the ones who should be putting this at the top of their agenda, and not things like, don't be rude to us at press conferences, or don't kick us out of the White House, right? This case, if it proceeds, and they should not sit back and say, "Oh, we're different. We wouldn't do the things that he did," because as Dan said before, if this case proceeds to conviction, not only are we going to see more prosecutions of publishers and journalists, but there's going to be a massive chilling effect because the lawyers for those institutions are going to know that prosecution is possible, and they are going to advise the editorial side to be much, much more cautious in their reporting, and that's going to be the biggest impact.
Well, and Ben, that reminds me, I rarely addressed, as you just did very well, the media role in this, but let me make 2 points. One very personal. During my trial, which lasted 2 years, and we had to raise a lot of money. In the course of that, there were 2 grand juries involved. There were people who had to be housed and fed during the trial for essentially 2 years. the New York Times never mentioned in the Times in any story about the case, and we were on the front page during the actual court proceedings every day, never mentioned there was a defense fund, let alone suggesting. No member of the New York Times picked up a phone, and the publishers, knew, everyone picked up the phone and suggested anybody that this was a good case to support. And actually, the Times lawyers refused to give my lawyers any of their briefs, that any research material they'd collected for the Supreme Court case. As one member of the New York Times said to another lawyer, a young lawyer who suggested they do that, it's one thing to defend the New York Times, it's another thing to defend a traitor. And they just didn't do it. So, and meanwhile, there was a scurrilous, slanderous story about me in the magazine section, which was the basis for my warning, Julian, don't be so shocked by the way they're treating you. That's what they do with every whistleblower, essentially, keep absolute arm's length. But the other thing I was saying was about journalists. Oh, no, I'm sorry, I didn't say this. I rarely have said it in this connection. I think there is a symbiosis between the media and the secrecy system, and that's not obvious. I think it works very well for them. They like to say, as various editors have said, well, the government tries to keep secrets, we try to get them, there's kind of a balance, it's good for democracy. Nonsense. The government wins that enormously more of the time than is good for democracy. Why would the press go along with that? Let me just make a guess. I'm not a journalist. I'm a source. But my impression is that when they are told, as happens every day, when an official of the government tells a reporter a secret, something that's classified, something they would not put out in a press conference, and they do this all the time to serve their legislative program or to serve an agency benefit or to make better the reputation of a particular official. They do it all the time. When they give them that exclusive, it's an exclusive because it's not given in a press conference. And so the reporter gets that scoop. High officials, usually they can't name them, high officials, but their editors know who it is, so they know they've got something here, say this. And then the next week, and know that other reporters don't have that story because it's classified. It has not been declassified by giving it to that particular reporter. Then, the next week, that official gives another secret to another reporter. Well, that's okay with the first one because his turn will come again. If he's a good boy, if he doesn't criticize, if he doesn't quote anybody who contradicts what this official has just told him, he'll get his scoop again. So I think they like the fact that they're able to get news on an exclusive basis because of the classification system, information that should never have been held secret at all, and that the public deserve to have or needed in some cases. Now, that's my guess, as I say, as a non-journalist. Maybe, Randy, you are a journalist.
Well, I'm not a journalist. Wait a second. I don't think anyone's ever taken me seriously. I'm a radio host and I'm a political satirist.
Sorry, I didn't mean to insult you.
No, but, I don't do any investigative reporting. You know, what Yahoo News did, that was investigative reporting. We had Alan Dorfman out. There are a lot of, what do you call it, alternative media outlets out there that have done stories on Assange. But I know this story that emerged by Yahoo News took Dorfman said it was almost a year ago when they got their first tip on it. So they really did their job, and there's a lot of substance to that story. Gentlemen, don't go anywhere. We're talking with the great Ben Weisner and the great legendary whistleblower Daniel Ellsberg. And joining us now, because there's been a lot of talk about what kind of trial would emerge in the Eastern District of Virginia in Alexandria. And someone who knows about that system, I don't know if you know him, Ben, but I know that Mr. Ellsberg does, and that is John Kiriakou, who has a radio show coming up soon. So he's on the other line. We're still waiting for Stella. Hope you can hear us, and please unmute or reconnect. John Kiriakou, welcome to Live on the Fly here on WBAI again.
Thanks, Randy. Thanks for having me. And what an honor and a pleasure it is to be with the great Dan Ellsberg and the great Ben Weisner. My pleasure.
All right. Well, listen, Ben, you've been doing a good job asking questions. I'm going to let you. You're a journalist on the side.
You're handing me the mic.
Yeah, I'm going to let you hand the mic because John and I have spoken a million times.
To bring John into this conversation. So I think one of the things that Dan and I were just talking about, John, before you joined, is really where is the media here? We've seen some comments upon the original release of the indictment where they said, look, this is a threat to investigative journalism, but they haven't done, by my count, two other things. They haven't been lobbying at a high level for these charges to be dropped, and they haven't really been covering Julian's case as the existential threat to national security journalism that it is. So you obviously have quite a bit of experience with the media on this, and what's your read on why there's why even national security journalists who should understand the stakes are not covering these proceedings more closely?
I think it's that, well, it's a couple of things. But the first thing that pops into my head is the fact that so few news outlets have a budget for investigative journalism anymore, that what they do is they essentially crawl into bed with the CIA. They'll take CIA pronouncements and CIA press releases and gist them and call it journalism. We know from Jason Leopold, for example, at BuzzFeed, that there are supposedly A-level journalists who send their articles to the CIA for clearance, like Ken Delanian does, before he even sends them to his own editor. So I think a lot of this is they don't have the wherewithal or even necessarily the desire to really do real journalism. And the other thing, too, is that I think that they're afraid of the CIA at the same time. I happened to participate in a Zoom call the other day with a bunch of attorneys and self-professed intellectuals and a handful of journalists. And there was a journalist there from Knight Ridder. And one of the attendees asked him specifically, why haven't you and others spoken out on behalf of Julian Assange, or spoken about the conditions that Julian Assange is suffering through, or even spoken about the issues that have gotten Julian Assange into his current predicament? And the guy came right out and said, because Julian Assange is an activist, not a journalist. And the questioner said, even if you don't think that he's a journalist, you have to acknowledge that he's a publisher. And the guy said, you know what? I don't want to talk about Julian Assange. And to me, that said that they're just afraid. They're afraid of provoking the CIA or the Justice Department, and they're hoping that if they just remain silent, this thing will go away and not affect them.
Right. We're talking.
Well, John, can I ask you, John, because you would know this point I made, if you heard it earlier, that the secrecy system actually serves the media to a considerable extent because it provides them with a flow of exclusives to one reporter at a time, which gives them scoops, which are very highly prized. And therefore, the fact that the classification system is keeping that information from being given to other people simultaneously is very helpful. Do you see anything in that?
I think you are exactly right on that score. Washington runs on leaks. If you pick up the Washington Post or the New York Times any day of the week, you'll see ostensibly classified information. The George W. Bush administration's classification czar, Bill Leonard, says that we have hundreds of millions of classified documents that ought not be classified. But they're classified just because they can be, and because they can be used almost as currency, as you said correctly, Dan, where the CIA and others can just dole the information out to preferred journalists, give them a scoop, and have the agencies story or the agency's version of a story be the story of record. That's actually a felony. What many Americans don't understand is that it's illegal to improperly classify information in the United States. Of course, nobody's ever been prosecuted for it. It's one of those laws that's been on the books forever that nobody pays any attention to. But the CIA and others can use it to their benefit.
If anyone has ever been demoted or in any way administratively punished or reprimanded for over-classifying a document, I'd like to hear of it. I've never heard of one. Not only have they not been prosecuted, I don't think they've ever had anything to suffer in their career from making something top secret that shouldn't be classified.
And I'll tell you another thing, too, along those same lines. I sat next to a woman in the 1990s when I was at the CIA who was dating a former senior CIA officer who went on to become a talking head at CNN. And in the course of pillow talk, she divulged to him classified information that he then repeated on the air. Okay? Well, we know, ever since the Obama administration, that's the very definition of an espionage charge, right? The Obama people would have charged her with espionage, and certainly the Trump people would have as well. So what happened to the woman? She was called down to security. They asked her, did you pass this information to your boyfriend? She said yes. They suspended her without pay for 4 weeks, and a letter went into her file saying that she couldn't be promoted for 1 year. Well, now...
Well, you've given me an example there. Then there's one person. That's more than I've heard of before. Go ahead.
Well,
that is
now,
one. That's one person. That's right.
But
I don't think they would have done that if it weren't something they didn't want out. If it were something that served the purposes of CIA or the White House policy or whatever, then she would have been more than reprimanded. But when the media have never, or really anybody else, but Congress or the press have not investigated the secrecy system as it should be investigated, because it's not just a matter of some abuses. The system itself is an abuse, a source of abuses to an enormous extent. In my trial, we called as a witness a man named William Florence, F. Florence, who had just retired, and he had just given testimony under oath to the Congress, Government Information Committee, on the secrecy system because he had written most of the regulations in the Pentagon over a 30-year career. And so he came and gave the same testimony under oath that he'd given to the Congress, which was this, that 5% of the information that was classified, he said, deserved classification at the time it was classified. He said, within a few years, it was 1/10 of that, 0.5%. So everybody agrees all the time there's overclassification, maybe 20%, maybe 30%, maybe 50%. Try 95% or 99% and a half. The presumption that people have when something classified is put out without authorization, that not the kind of that it hurts national security to have that out. That should not be the presumption. And in addition to the reasons you gave, John, you have to add the fact, or I'm sorry, it was Randy, you have to add that so much of it, not all of it, of course, but so much that is classified indefinitely because it would reveal deception, even criminality, violation of treaties, as in the Pentagon Papers case, for example, enormous, what Snowden revealed, enormous violation of the Fourth Amendment, domestic criminality, as you revealed, torture, without even meaning to, do anything that violated the regulations. But you revealed, as I understand, the name of somebody who had been involved in torture. Should that really have been concealed? Remember that the entire torture report, 6,000 pages of the Senate the Committee on Torture, remains classified. We have only the highly redacted executive summary of that, and to this day, it's not been released. That's why it's all domestic crime and international crime. Every page of that, I would imagine, reveals that, and that's why it's classified.
And Dan, that's why authorities at NSA, for example, or at CIA have been forced to come out and say that the information that Chelsea Manning revealed or that Ed Snowden revealed did not cause any harm to the national security because it was improperly classified in the first place. There's no reason, for example, that Reality Winner should have gone to prison. That was
Right.
an analytic document that should never have been classified in the first place. It was only classified because somebody from NSA had written it. That's not a reason to send somebody to prison for 5 years and 4 months.
Right.
But we see that every day. The system is broken.
Randy
Well, I'm not
and
sure it's
John and
broken.
Dan,
It does what
I
it's meant
apologize.
to do. It keeps information from the public, not just that needn't be classified. That's most of it, needn't be classified, but it keeps from the public information the public particularly needs to know that would hold the officials accountable for deceptions, for crimes, for false predictions, let's say. All of that has to be kept classified to avoid embarrassment. So the system is working to do what it really is meant to do, not what the regulations say about national security, but the reason that it's really there. It works very well.
I'm going to have to leave this conversation in Dan Ellsberg's and John Kiriaku's able hands, Randy. I've been on 45 minutes longer than you expected.
Yes, well, I know, but you did a magnificent job filling in for me. We finally got Stella there, so we're going to say goodbye to you.
Take care.
And
Thank you
we're
so
going
much for
to
this
say goodbye.
conversation.
Thank you very much, Ben. You were fantastic, and we'll see you soon. And, John, I know you got to get to work, and you have anything else to say? Do we have Stella now? I think she's unmuting.
I just want to say to keep up the good work. I can't imagine a more important cause than the life and the freedom of Julian Assange. And I know that this is a process. I know it's going to take maybe another year. But in my gut, in my heart, I know that we're going to be victorious because Julian did nothing wrong.
Okay. Hey, that's John Kiriakou. Thank you. I want to thank Ben Weisner. Dan, you're going to stick around here. And good luck. We'll be talking to you soon, Mr. Kiriakou. I'm Randy Credico. This is Randy Credico Live on the Fly. And at last, we do have, and this is my fault because I thought there was a 5-hour difference between here and London. There's only a 4-hour difference because they changed the time. And we do have now human rights attorney Stella Morris. You're still there, Dan, right?
Yes, I am.
Okay, so stick around. Don't go anywhere, Dan. We are joined now by Stella Morris, who is the partner of Julian Assange and the mother of his 2 children. Welcome, Stella.
Hi, Randy. Hi, Dan. How are you?
Hi.
All right. Well, I guess there is only a 4-hour difference there. Stella, we've been talking for the last hour on this case, and I know you've gone through a lot, and I don't want to get into all of that, but people here don't know what to do at this point in time. Many of us, we feel hamstrung. And I know that you have some advice, what people can do, and which includes supporting the Defense Fund. So why don't you give us an overview of what we can do here?
Right. Well, Julian is, it's really a David against Goliath battle here because the way the case is rigged against him in so many ways. The U.S., the DOJ has had, 11 years to try to mount a case. They haven't been able to mount a case, but they've been able to issue an indictment and issue an extradition warrant. And the UK then represents the U.S. in court, and the UK taxpayer pays for the U.S. Government's bogus case against Julian, and then Julian has to raise his own funds to mount a defense. So it's a David against Goliath battle in many different aspects, but the financial one is one, and that's a way that people can very meaningfully contribute to Julian's defense and to his freedom.
Yeah, let me just, Dan, you were talking earlier about your defense fund, how difficult it was to raise money, but people did come forward and give money to the Daniel Ellsberg Defense Fund, if I'm not correct.
Absolutely. 25,000 people actually contributed to it. And that was at a time when they had every reason to think that would put them on a government list of some kind, as had happened in the past. But it was a very wide participation.
And Stella, so how do people, and I'm asking everybody out there, I know the legal battle, I know the lawyers, there's a lot of lawyers, but there's a lot of paperwork, they still have a lot of obstacles ahead of them, and how do people actually I know they can do it here with NYC Free Assange. They have it on their front page to make a donation to the Assange defense team. How do they do it otherwise?
Well, the easiest way is to just go to my Twitter feed, which is Stella Morris 1, Morris with 1 R. And my pinned tweet there is the Crowd Justice fundraiser that I have set up. The money there goes to Julian's extradition legal team. And I post updates there periodically during the hearings. It's daily. And you get an email with my updates and alerts and so on. And of course, there's the defense website with more details. And if people want to donate via cryptocurrency, there's also that option. And if they don't know how to donate or if have some specific requests about the way they want to donate, they can always contact me directly over Twitter, DM. I have open DMs, and there's always a way.
That's Stella Morris with 1 R, Stella Moris 1 at Twitter. That's one way you can get. And I'll ask both of you. I mean, you're going against two huge, the endless supply of money. We're talking about the CPS, Crown Prosecutor Services in the UK, and in here, you got the Justice Department. How much money, do they have, Dan? You're facing a giant here, money-wise.
In a way, people can ask, how can it be that they are pursuing Julian this way for, as you say, 11 years? And one answer is that Julian, as David, did take on the Goliath. He was actually threatening the veil of secrecy that protects criminality and imperialism and torture, as he revealed. Chelsea Manning was giving him information on that. Death squads all over the world. And that was a threat to pretty much every country in the world, especially those that are more imperial than others. So in a way, he was taking on the world establishment, the ruling class, the imperial powers, and it's shouldn't be a surprise that they're throwing all this at him and that they'll never forgive him. And on the other side, Stella, if I may say, I really thank you because as a friend of Julian's, that it is your loving support and your support of his children, your children, that is keeping him alive. So I really want to thank you for that.
Thanks, Dan. I think it's our love for each other that's kind of been an amazing thing in the middle of this nightmare. But Julian also has so much support around the world, and whenever I see him or speak to him, I make sure to tell him about the many different actions people from the grassroots, but also organizations that are more and more organizations are coming on board and making gestures, like the German section of PEN International yesterday made Julian an honorary member on the day of the International Day Against Impunity of Crimes Against Journalists. And it's that kind of thing. It's just building and building. I just noticed today that the UK, the US, and Australia, who have this thing called the Media Freedom Initiative, they issued a statement about killings of journalists and persecution of journalists, and this, to me, it's not really a sign of hypocrisy. I've kind of evolved in my understanding of what they're doing. It's just deflection. They're trying to regain control of the narrative because it's slipping away, because the prosecution of Julian is such a clear political persecution, and it's plain for everyone to see. Dan, you want to respond to that?
Well, I agree that he deserves that support, and as I was saying, he should be getting a lot more than he is with the help of the media, who are not joining him. But Stella, I'll tell you, as I'm listening to you, I'm thinking that a book that came out about whistleblowers, and there have been innumerable whistleblowers in the civil field, which also involves a lot of death, like tobacco, and the Sacklers, OxyContin, where, by the way, there seems to have been very few whistleblowers on the OxyContin case. But in most of those cases, said the lifespan of a marriage was 18 months, according to this. It almost, in my time, there weren't that many whistleblower cases, but the anti-war resistors who went to prison, mostly it broke up marriages. The strain was just too great, and it didn't, and the people hadn't signed on for that, and it was bad for the marriage. So my case is very unusual there, where Patricia and I were, if anything, closer. We've just had our 50th anniversary, and Jeffrey Sterling was very much supported by his wife, and John, my understanding, if John has left, but John Kiriako's marriage, helping him, support him during that. Well, in your case, you joined him during this case, and as I said before, I'm sure that it's that support that is keeping him really sane and alive under extremely bad conditions. I am one of the few whistleblowers from a national security field who did not suffer personal consequences, essentially, although the government had those in mind. I was faced with a possible 115 years in prison, nothing compared to Julian's 175. But in terms of our lifespan, probably come to the same thing. But in my case, by almost a miracle, Nixon was deprived of his ability to ruin my life, didn't do it at all. But in many cases, of course, it has done that. And so I come back to the thought that I really appreciate, Stella, your support. And I've talked to his father, John Shipton, and his half-brother, Gabriel. And, of course, they've made a tour over here for funding for him. And I'm very glad you're making the pitch for funding. And I was just thinking that I was derelict in not raising it myself.
All right. Well, you know what? We're talking with Daniel Ellsberg and Stella Morris, human rights attorney. And you can, I want to say it again, you can donate to the campaign, the defense team here, and let me just put in, it's NYC Free Assange here. They have a donate button that goes straight to what Stella has just mentioned, but you can also go to, and you should follow her because you'll get like incredible information. That's at Stella Morris with 1R1 on Twitter. And I urge everybody out there, please support this defense team. It's really vital at this point in time. And Stella, let me talk about other actions. There are groups. There's here in New York, the Courage Foundation. You got Defend Assange. You've got other groups in D.C. and Denver. You got them in San Francisco. And what's your message to them? Because they're looking, a lot of them, what do we do at this point?
Well, we need to get the congressional representatives aware that people are outraged about this case and want it to be dropped. That involves, making the people, regular people, aware of what this case is. If you have a cafe or a bar or whatever, set up a petition, gather signatures, get information to people, go to the rallies, and get good information because follow me, follow WikiLeaks, follow the DEA campaign, the accounts that I promote are good sources for information, and don't expect the media to be on top of this case because they've failed dismally. Yahoo News did an excellent investigation, and some of the channels did do good coverage of it. CBS did a very good report, to their credit. The New York Times tried to avoid it. They mentioned it for the first time only after it had been mentioned in the extradition case on Thursday, and then it was mentioned. So, that they can't avoid the true nature of this case forever. But in the meantime, we have to stay informed proactively.
Absolutely. And if there's anything else, I know it's getting late there, and you got family obligations at this point, so if there's anything, Dan, you want to ask her before we take a break and bring in one of the witnesses, Robert Boyle is going to, and I want you to stick around, Dan. Do you have for Miss Morris?
This is maybe bad news. I don't want to raise it, but I will. That is it the case that we expect? Is Ben still here? I would ask Ben.
No, Ben's not here. Ben's gone.
Oh, but is it the case that the government is able to appeal if this goes in favor of Julian, which means that he would have to stay in prison anyway if they do go in favor of Julian? Is that the case?
They can try to appeal to the Supreme Court, and then the Supreme Court could choose to hear it or not. Yeah. I mean, right now we're faced with two prospects. One is that that Julian could win, and that he could lose, and if he loses, this could go on for a long time. Even if he wins, there's a risk that he could be, snatched, and it's possible that he could be extradited to the U.S. Before the summer as well. So we're both prospects of Julian remaining in prison for a long time, or being snatched, are terrifying, and basically the Biden administration has to drop this case.
Yeah.
Well, that gives us another deadline here. If they do rule in favor of him, that would be the time for a heavy, widespread pressure as much as possible on Biden not to appeal that ruling to a higher court. In other words, we'd have another crack at that if we face that. Is that right? Sounds right.
Yeah, that's right. But I mean, either way, the Yahoo story sets there's a before and after this Yahoo story about the plans to kill Julian by the CIA under Pompeo.
By the way, obviously, Congress should be investigating that. These well-supported allegations of criminal activity by the CIA and others against an American citizen, and they should be investigating that, and they're derelict if they don't. But one last question, Jill. When has Julian been able to see his children face to face under these conditions?
He has, yeah, and we go to the prison once a week, more or less, and he's able to hold the kids and read them stories, and they love going and seeing him, and it's really nice when they're together, and
just
everything's
30
normal
seconds.
for about an hour, and then we go back to this madness.
Well, I hope they may be too young to know, but I hope they will learn how many people in the world are supporting their father.
We got to continue that support, folks. And as I said, I'm going to say it again, here in the U.S., if you don't aren't on Twitter, you can go to nycfreeassange.org and donate. It directly goes to what Stella had just informed us on, or you can go to Stella Morris with one R at Twitter, and please, folks, around the world, let's do it. Tell everybody, and we're in the barricades right now, and we got to keep fighting. I want to thank you, Stella. We're going to let you go here at this point. We're going to come back with and Dan, you stay there. You're a good co-host, so I'm going to keep you there. Stella, we'll be in touch. Thank you once again, Stella Morris, human rights attorney and the partner of Julian Assange.
Give Julian my love, will you, Stella? Thanks.
I will. Thank you. Thank you, everyone.
All right. We'll be right back. This is a little piece by Nils Melzer, and we'll be right back with Robert Boyle, one of the who provided testimony last week. We'll be right back. This is Nils Melzer playing Moonlight Sonata. Don't go anywhere, anybody. Okay, that was Moonlight Sonata. Who knew that Nils Melzer, who gave me that piece of music, played classic piano. I'm Randy Credico Live on the Fly here with a special edition of Live on the Fly, Assange Countdown to Freedom here in New York City, WBAI. And we're covering the Assange hearing last week. And one of those, and we got Daniel Ellsberg and my co-pilot today. What an honor that is. We have Robert Boyle, who provided testimony during the hearing last year and last week during the appeal. Robert Boyle is a great attorney, an old friend of mine, and a student of William Kunstler. Welcome back to the show, Robert.
Thank you for having me, Randy, and hello to someone I really look up to, Mr. Ellsberg. Honored to be with you.
Thank you.
All right. So go ahead, Bob. Last week, the U.S. government, they said that Julian's okay. The conditions are great in this country. He doesn't face risk. He doesn't face, depression and suicide. What did you actually submit there? Could you summarize that for us?
Sure. In support of its appeal, the U.S. government gave so-called assurances to the presiding officials in the U.K. As you know, the extradition request was turned down, not on the merits, but on the fact that the English government could not be assured that Julian Assange's mental and emotional health would be sustained should he be transferred to a U.S. prison, and we know that he's suffered, up until now. And so they made certain representations, which, as a federal practitioner here in the States, I was asked to review them and to point out to the court, the holes in them, that are the size of a Mack truck. So basically they say, well, first of all, we're not going to put Mr. Assange under what's known as the SAMs, Special Administrative Measures. Unless, of course, they say, he does something to justify imposition of the SAMs. Well, right there, that leaves it totally up to the U.S. government as to whether anything he does, be it speak to the media, be it, writing articles, can justify being put under special administrative measures. And what they are a great prohibition on communication with people in the outside world. Under special administrative measures, individuals who are incarcerated, and there are a lot in this country under special administrative measures, can only speak to certain people, if any. They're denied contact with other inmates. And, for example, I've had clients under special administrative measures, and, I'm not allowed to, under contempt of court, I'm not allowed to say anything about the substance of what they tell me, even if it's not. I mean, I don't do that anyway in terms of attorney-client communications, but even confidential communications, I can't discuss it with anyone. Now, the government says, well, we won't put Mr. Assange under a special administrative measures. Well, you know, the SAMs are onerous, but being in a maximum security prison in this country is onerous and denies much communication with the outside world. Under general BOP regulations, you're only allowed to communicate with immediate family. Your letters are censored, and letters coming in are censored. You're only allowed a certain minimum number of visits, and only then with immediate family. And in many of the maximum security prisons in the federal system, those visits are not contact visits, they're through plexiglass. So these are the, you know, even without the SAMs, these are the conditions that Julian Assange will be under should he be extradited to this country. Now, also, the U.S. government makes the representation that since the United States and Australia are part of a treaty, and not an extradition treaty, but a repatriation treaty, Julian Assange, the U.S. would not oppose the transfer of Julian Assange to a prison in Australia should he be convicted in this country. Well, you know, that's another, you know, very vague so-called promise. First of all, the Australian government has not consented to that. So that would obviously be necessary. Secondly, we're talking something that's years down the road at that point. And this gets to another, I think, important point, that should Mr. Assange be extradited to this country, his criminal defense and the preparation for trial will only really begin at that point. It could be a year or more after he's extradited that trial would even commence.
Wow. Wow.
The trial itself could take months because it's a complicated case involving, you know, tens of thousands of documents. If he is convicted, it's not unusual in the federal system for the sentencing proceeding to take place 4 to 5 months after the jury's verdict.
Wow.
Then you, once he's sentenced, of course, he has the right to appeal to the Federal Court of Appeals. In my experience, in complex cases, it takes 2 to 3 years for those appeals to be resolved because the record is enormous. You have to write a brief. The government has to write a brief. You get to reply. Then it's put on the court's calendar. Then it's set for oral argument. And then the court issues a decision, but the court can take however long it wants to issue a decision.
Wow.
In that situation. So the government is making, the U.S. government is making the argument to the U.K. government, well, you know, he's, not going to be in,
Supermax
conditions for very long, but the situation is he'll be under intensely, egregiously conditions, while he is awaiting trial and even after trial, even if Australia would consent to take him, which is something, obviously we want to win at trial, but it's going to be years.
All right, we have been talking. We only have a minute left. I mean, really a minute. Daniel, if you have very, very cogent points you made there, Bob. Mr. Ellsberg, if you have, we have 1 minute. Anything you want to add to that? Then I'm going to have to say
No,
goodbye.
I've been listening and learned a lot. Not all good news from Ben Weisner, but I loved hearing from Stella Morris. I'm so I believe the U.S. government wants Julian Assange to die in prison. And if that's, I don't think they want a trial here. They don't want these issues debated or the media to take more concern than they do when he's rotting in a British jail. So I don't think they want him over here. They want him endlessly in that Belmarsh prison and to die there. Right. And I think it's the knowledge of our support and the programs like this and all around the world, and above all, as I said earlier, that he has Stella Morris and 2 children waiting for him and supporting him now, that will keep him alive. And I don't want to see him die in that prison. I want to see him out.
Right.
And that can only be done really by the U.S. dropping these charges, and that's what President Biden should do, absolutely.
All right. Bob, 30 seconds. Any conclusion in 30 seconds here?
Well, there's not much more that I could add than what Mr. Ellsberg said, but the conditions in U.S. prisons are horrendous.
Right.
Horrendous.
Of course, we know
it's a death sentence to be sentenced, into one of these places, and we must fight to prevent Julian Assange from ever coming back here.
Okay, that's the last word. I want to thank Robert Boyle, Attorney Robert Boyle, the great whistleblower, legendary whistleblower, a real hero of mine and everybody else, and that is Mr. Daniel Ellsberg. I want to thank Stella Morris and Ben Weisner and John Kiriakou. We're going to go out. This is a little bit of My Forgotten Man. This is from Gold Diggers of 33. This is Joan Blondell. It's an anti-war song from World War I.
Put a rifle in his hand. You sent him far away. You shouted, hip hooray! But look at him today. Remember my forgotten man. You had him cultivate the land. He walked behind a plow. The sweat fell from his brow. But look at him right now. And once he used to love me. I was happy then. He used to take care of me.
This is Julian Assange. You're listening to WBAI New York. Stay strong and keep listening.